Hi, everyone at FindMyLawTutor. Today, we're joined with Stacey Montgomery. Ms. Montgomery is going to give her 7 tips for legal writing. Good morning, Ms. Montgomery.
Good morning.
Thank you so much for joining us here at FindMyLawTutor.
Oh, thank you for having me.
Now, Ms. Montgomery, could you tell the students here at FindMyLawTutor a little bit about your background in the legal field?
Sure. I am a graduate of Boston University School of Law and have passed the Illinois Bar. While at Boston University, I was an editor on the Probate Law Journal and editor-in-chief of Legislative Services. After law school, in addition to practicing at private law firms, I was also an adjunct instructor for legal writing at the John Marshall Law School. And I've also published a number of articles, both in legal journals and in non-legal publications.
Thank you for joining us. And today you're going to give us your 7 tips for legal writing. What's your first tip?
My first tip is to use short sentences rather than long run-on sentences. Short sentences help bring clarity to legal writing, particularly when trying to express a complex issue. So instead of saying the defendant used threatening, hostile, and derogatory language toward the plaintiff and continued to threaten the plaintiff even after the plaintiff no longer worked on the location. That's 27 words. You can make that a lot shorter and clearer by saying it like this. The defendant threatened the plaintiff, period. Next sentence. In addition, and then go on to complete your next thought.
What's your tip number 2?
Use active voice rather than passive voice. Using passive voice can cause wordiness and ambiguity. For example, instead of saying the ruling was made by the court, just say the court ruled. You've used fewer words and your point is clear. Now here's a tip to help you determine passive versus active sentences. Passive sentences tend to begin with it was or use the word by. For example, the ruling was made by the court. Active sentences tend to begin with the subject. The court ruled.
What's your tip number 3?
Avoid redundancy. Redundancy causes wordiness. Instead of saying cease and desist or null and void, just say stop or void.
And your tip number 4.
Avoid legalese. Lawyers tend to use outdated, often pompous-sounding words or phrases when a simpler word would provide greater clarity. For example, do not say in as much as or aforesaid. Simply say since or previously stated. And also use Latin phrases sparingly. For example, use phrases like de minimis, which means minimal or insignificant. Just use the English translation. Do not use inter alia, which means among others or and others. However, there are some phrases, Latin phrases, that have become part of our everyday legal and non-legal discourse so that there is little chance of ambiguities. So, for example, it is okay to say pro se or habeas corpus or mens rea. But in general, try to avoid using Latin phrases.
What's your tip number 5?
Be specific with names, dates, and places. For example, instead of using procedural titles such as plaintiff or plaintiff appellant or defendant appellee, just use the person's name, like John Smith, because as a case winds its way through the various stages of litigation, procedural titles can change, and that can cause some confusion. Also, instead of saying the day in question, be specific about the date and say May 6th or whatever the date is. And as for places, instead of saying the scene of the crime or the scene of the accident, simply say where the accident took place, like the Walmart parking lot on the Main Street.
What's your sixth tip?
Avoid double negatives. Do not say not insignificant or not uncomplicated or not uncommon. Simply say significant, complicated, or common. Again, you're using fewer words. It's easier to say, and it is just as clear, if not more clear.
And your last tip for our students.
Proofread, proofread, proofread. I cannot stress this one more. After you finish drafting your document, read it over and edit. And if you can, have someone else look it over for you as well. But just check your work.
So just to recap, your 7 tips are short sentences, active voice, avoid redundancy, avoid legalese, be specific, avoid double negatives, and proofread.
Yes.
Ms. Montgomery, are there any consequences of bad legal writing?
Yes, there are. And the consequences can actually be quite severe. For example, you could actually be reprimanded by your bar association for writing badly. An attorney in Minnesota back in 1993 was reprimanded by the Bar Association for repeatedly filing documents the court considered unintelligible. In addition to being reprimanded, this attorney was required to attend legal writing courses. You can read more about that at N. Ray Hawkins, 502 Northwest 2nd, 770. Another consequence is that you can actually lose your case. In Mississippi, a defendant appealed a district attorney's burglary indictment, arguing that it did not charge him with anything because the document was so poorly written. And you know what? The court agreed and threw out the indictment, saying that it was grammatically unintelligible. You can read that at Henderson v. State, 445 Southern 1364. That's a 1984 case. So again, not only do you want to make sure that your clients and co-counsel can understand your work, your writing, you want to avoid being professionally reprimanded or embarrassed or losing cases for as a result of bad writing.
That seems very severe, and it's so important to write well. How amazing. Thank you so much for being with us. Ms. Montgomery, we really appreciate